I got about a half hour, so I thought I'd shoot a quick video and talk about what just happened and what's been happening here in Michigan. I was arrested, prosecuted, and found guilty by a jury and sent to prison on a complaint that failed to accuse me of a crime. This is something that's not supposed to even be possible. Before a criminal complaint is acted upon, it's actually verified by 5 different people in the county. Starting with the sheriff's department or the police and the junior prosecutor. The complaint is prepared, it's presented to the prosecutor, and then verified and approved by the prosecutor. And then it goes to a judge for the issuance of warrants. So we've got the police, junior prosecutor, the prosecutor, and the warrant issuing judge. And the 5th person is the judge in the district court that arraigned you on the charge. Or not. See, the judge, according to the court rules, is supposed to verify that a complaint complying with Michigan Court Rule 6.101 has been filed at or before the time of arraignment. So that's the 5th person in the chain with regard to verifying that a complaint meets the requirements of a complaint under the Michigan Court Rules and Michigan law and the Michigan Constitution. So, Michigan Court Rule 6.101 is about the complaint. It's the definition and form that is required to be used with regard to initiating a criminal action in a Michigan court. So, ironically, all 5 of these people, in my case and in many other cases, are not following the rules. My complaint says that I did something contrary to Michigan compiled law. And that's all the detail that's given with regard to what I'm accused to have done. I've done some research and I've figured out that since the people of Michigan enacted the Michigan Medical Marijuana Act in 2008, the criminal complaint regarding or having to do with marijuana had to be revised because all of a sudden there's new legislation that says that under certain conditions medical marijuana is now permissible, where prior to that, all marijuana was criminal. So what happened in 2008 is we got new legislation that replaced the old legislation from the Michigan Public Health Code, Michigan's version of the Federal Controlled Substances Act of 1970. So in 1978, Michigan enacted the Public Health Code with regard to the controlled substance regarding all controlled substance in 1978. So anyways, in 1978, Michigan, through its Controlled Substance Acts, part of the Public Health Code, made all marijuana possession, delivery, manufacture to be a crime in Michigan. Now the words used to criminalize aspects of marijuana are very important here. Possession, delivery, manufacture, those were the actions that constituted a crime since 1978. The Public Health Code never made the sale of marijuana illegal. because it was covered under delivery and it didn't need to be listed. Additionally, it was done for the specific reason, a couple specific reasons. Number one, it's easier for a prosecutor to prosecute you for possession or delivery rather than sale, because there's a lot less to prove. So the prosecutor's job is made easier by the way the laws were written with regard to marijuana, or any drug for that matter. It was never really about the sale, it was about the delivery and possession. So with that in mind, the Michigan Medical Marijuana Act made legal the medical use of marijuana in 2008. And the Medical Marijuana Act defined the medical use of marijuana as acquisition, possession, cultivation, manufacture, extraction, use, internal possession, delivery, transfer, and transportation of marijuana. That is what the definition of medical use of marijuana is. That is what the people of Michigan paid the state for permission to do. Acquire, possess, delivery, manufacture. These are all the permissions that were sold to medical marijuana primary caregivers and patients by the state of Michigan. It's also equally important to note that among those things that define the medical use of marijuana, that buying and selling are not specifically listed. And there's a good reason for that, in that Michigan had never previously made the sale of marijuana or buying marijuana the crime. Instead, again, the crime was possessing marijuana. So on my criminal complaint, it says across the top in all caps, delivery, manufacture, controlled substance, marijuana. Now, according to the Medical Marijuana Act and the fact that I'd paid to participate lawfully in the medical use of marijuana, my complaint to me did not tell me what I was doing wrong. It only suggested that it was a felony to do what I paid the state money for permission to do, deliver, manufacture marijuana, as being critical parts under the Michigan Medical Marijuana Act and its definition of the medical use of marijuana. The courts, judges, prosecutors, police think that the medical use of marijuana is smoking a joint, and that's the mentality that they've adopted to prosecute people in Michigan on faulty complaints that fail on their face to accuse the defendant of a crime. I can't tell you how important it is, how critical it is for a criminal complaint to actually accuse somebody of committing a crime. Without it, the court lacks jurisdiction over the subject matter, meaning any court that takes action over a criminal defendant that hasn't been put on notice of what he's alleged to have done wrong constitutes one of the most significant due process violations you can imagine. So in my trial, in my prosecution that lasted more than a year, I'm defending myself against unstated allegations. And the court knew that, and that's why the judge, Harry P. Gill, ordered me to sign a voluntary request for the appointment of counsel. Judge Gill didn't want me bringing this up in court, and prosecuted me criminally inside of my criminal prosecution for criminal contempt of court, so that he could violate my bond conditions by finding me guilty of a crime, which was a bond condition. And in fact, contempt of court is the only criminal conviction that can happen when the court needs it to, in order to violate somebody's bond condition. The courts don't want to take a look at this faulty complaint issue because Michigan prosecutors and most of the 83 counties have been prosecuting people on a faulty complaint. See, in 2008, the prosecutors in Michigan realized that they couldn't prosecute people like it was 1978 anymore because not all marijuana was criminal. So what they had to do was rewrite the criminal complaint. And the way they did that, it's almost like they started to edit on a Friday and forgot to get back to it on a Monday. Because the criminal complaint has a piece missing, has two pieces missing. And with the pieces missing, people are being prosecuted and have been prosecuted since 2008 and probably even before that on complaints that fail to accuse people of a crime. There is no greater defect in a court proceeding than when a court proceeds without subject matter jurisdiction. Subject matter jurisdiction in a criminal case is the allegation of the crime itself. Without an allegation of a crime, the court can do absolutely nothing but dismiss the case. And when the court knowingly, which in my case it did, when the court knowingly proceeds without subject matter jurisdiction, they're exercising power and authority that they don't have. They were never given power and authority to just manhandle people without a cause of action. Without a cause of action, there is no case to be tried. Without a case to be tried, the court has nothing to do. So anything the court does when they don't have subject matter jurisdiction is a complete nullity from the beginning. Now, since the complaint doesn't accuse me of a crime, it creates another problem for the state of Michigan. I'm not the only one that's been prosecuted this way. In fact, hundreds, if not thousands of other people are affected by these same defects. So it's very important that this video gets shared a lot in Michigan, because Michigan prosecutors have been prosecuting people illegally in courts without subject matter jurisdiction on faulty complaints that fail to convey the required subject matter jurisdiction to the trial court. This compounds my problem because I don't have to necessarily just address my own issue here with the malicious prosecution in Bay County, Michigan for myself, but also it creates a situation and a scenario where the Michigan Court of Appeals and the Michigan Supreme Court have been confirming convictions on faulty complaints. They don't even look at the complaint at that point. Now keep in mind, these 5 people are supposed to verify that this complaint is proper and that it conforms to the court rules. And